Healthcare is too expensive. Employers are offsetting costs onto their employees. Who will make health benefits affordable for hard-working Americans and their families?
You will! This is the Empowering Plans Podcast, a show dedicated to helping you once again emphasize the benefits in your benefit plan. Now prepare to learn,
Plan,
save,
and protect with the FIA Group.
Welcome to another episode of Empowering Plans with the FIA Group. My name is Cindy Merrell, and I am the Director of Legal Recovery Services at FIA. And today, we're going to talk about a case that just came out of the 10th Circuit earlier this summer in June. And I think this case is worthy of mention because it gives us some insights into what a court may look to when there is litigation involving a denied claim. The case we're going to talk about is E.O. versus Primera. I think the first thing we should start with is to note that ultimately, court never said the plan made the wrong decision. Instead, the court took issue with the process of the decision. So there's a big distinction here that I think is worthy of mention right off the top. All right, let's jump into the facts of this case. So a minor participant initially sought coverage for residential mental health treatment. The plan denied portions of the treatment as not medically necessary. Ultimately, the plan appealed and filed suit. And the court ruled in favor of the participant, finding the denial was not adequately supported by the administrative record. I think there's three key takeaways here that are valuable to our listeners. And the first one is your administrative record is everything. In cases involving ERISA denials, a lot of the time, the administrative record often becomes the entire case. Ask yourself, would a judge understand exactly why this claim was denied? Think about it like this. When I was in law school, I was an intern for a politician. And something that they always stuck with me my whole career was everything you do, would you be okay with that being on the front page of every newspaper? And I think most of our plans, those denials are well documented. Their decision making is easy to follow. You want to make sure that your record can tell a complete and logical story. So document, document, document. The second key takeaway is explaining why. My daughter is going back to school, coming up here in just a couple of weeks. And I'm sure that we all have, if you don't have a child, I'm sure when you were in school, remember your teacher telling you to show your work. Explain why a decision was reached. I think of it like this. My daughter looks at a math problem and she can come to the correct conclusion because she's thought of all of those things from her experience and her just sheer talent at math, which I do not have for the record. But she can look at a problem and quickly come to that correct conclusion. However, the court wants you, the plan, to explain why you reached this decision, not just a statement of that you reached this conclusion. How did you do that? Show your work. Explain what you looked at. Explain why you interpreted this to reach this conclusion. I would identify which plan provisions apply. I would not keep broad, overly generalized denials. The court wanted to see a very detailed explanation so a plan participant can understand why the claim is being denied. I would also make sure the court talked about why the claimant's evidence doesn't support the payment of that claim. Clear explanations reduce confusion and reduce the litigation risk. And I would say the next key takeaway is the appeals must be meaningful. The appeals process is more than just a second signature on the original denial. Administrators should consider any additional new evidence that was brought for their consideration, address treating physicians' opinions. It would be a gross overstatement to say a treating physician is always correct, but we do have to address at least why their opinion is different and you don't reach the same conclusion. Explain more specifically what the plan agrees with and what they may take issue with or disagree or need some additional information. A thoughtful appeals process demonstrates a prudent fiduciary process. And I think that overall, the key takeaway is the courts aren't just reviewing the outcome. They're reviewing the process. The strongest defense is well-documented, well-reasoned claims that consistently apply the plan's terms. Thank you for your time today. I know it was a brief one, but this was very important. And if you have any questions, feel free to reach out to us here at the FIA Group. Thank you.